Good morning, everyone, and welcome to our webinar on managing disputes for in-house legal counsel. My name is Rebecca Wood, and I'm the practice group leader of the disputes and litigation team here at LegalVision, and I'm joined today by my colleague, Julia Cremona, who's a senior lawyer in my team. Before we get into the main content of the webinar, we've got a couple of quick housekeeping items to cover off. So firstly, no need to take notes. You'll receive a copy of this recording and the slides in your email. Secondly, we have an opportunity to answer your questions. So please submit your questions into the chat box at any time, and we'll answer them at the end of the webinar. Finally, please let us know what you thought by completing the feedback survey at the end of the webinar. So thank you for joining today, and as a result of joining, you'll be eligible for a free consultation with LegalVision to understand and learn a little bit more about how we can help your in-house legal team manage your high volume and business as usual legal needs, which would allow you to focus on the most important tasks. If you'd like to take up this opportunity, please provide your contact details in the survey at the end of this webinar. So today we're going to be discussing how to undertake an early case assessment of a potential dispute or dispute and early resolution, managing external legal counsel, preserving professional legal privilege and managing information, commercial strategy, and how to apply continuous improvement and learning in your work. Finally, we're going to have an opportunity to answer your questions. So as I said earlier, please submit them into the chat box. Okay, so I'm going to get started by talking about early case assessment and resolution. So as an in-house legal counsel, your role in dispute management is multifaceted. Not only are you responsible for providing legal advice to the business, you're going to be representing the business and also the key person for aligning the dispute resolution strategy with the overall business objectives of your organisation. So your role requires a deep understanding of your company's operations, priorities, and risk tolerance. So when faced with a dispute or a potential dispute, it's really important to undertake a thorough early case assessment. So this involves reviewing and collating the relevant information and materials at the outset, and then undertaking an analysis and assessment of your legal position, evaluating the potential risks and outcomes and balancing them against those commercial drivers and risk profile of your organisation. So let's start by talking about collecting information. So first and foremost, you'll need to identify the materials, evidence, and people that are relevant to this particular issue. So this is going to push you to understand early what, if any, is missing in terms of information, what questions you might need to be asking, what information you might need to seek out, and who do you need to help you with this journey, essentially. You might want to consider issuing a legal hold notice to the employees of your organisation. So this will essentially be a notice to suspend any routine deletion of electronic data and collection and securing physical evidence. So it's going to be important to cast a wide net initially to make sure that you're collecting as much information that might be potentially relevant as possible. And then you might later narrow down the scope of that hold as the evidence and the issues in the case become clearer to you. A lot of businesses will usually revert to a managing director or senior management to provide a statement of events, but they might not be the people that are, I guess, closely aligned with what's actually happened. So you might want to consider who the most relevant people are to this dispute. So, for example, if a dispute is in relation to a particular incident that's occurred within the organisation, you might want to talk to the people who were there at the time, who've witnessed it, or who can speak to the incident and can provide some context. For example, if you're dealing with a contract dispute, you might want to speak to the people who were involved in negotiating or administering the contract at the outset. And then also the people that have been involved in the lead up to the particular dispute. So the sooner that you do this, the better. If you wait too long to start reviewing and collating evidence, you might discover that the information that you need has been destroyed. The business hasn't retained the information, or for example, the information might not even exist. The relevant people that you need to speak to have left the business, and now you've got no ongoing contact with them. We find this happens a lot. And the reality is that people will come and go from organizations all the time. And so, it's important to seek out and get relevant statements, information from people as soon as possible before they've got an opportunity to leave once a dispute arises. Once you've collated all of the information, you might find that the evidence that supports your position is actually not as strong as you believed, or perhaps the individual viewpoints of the people that you're speaking to are not actually backed up by a documentary set of documents, essentially. It might not be backed up. So look, once you've collated and reviewed this information, you need to identify the key legal issues and assess the legal position. As I set out before, it's important to be understanding the strengths and weaknesses of your organization's position and align them with any potential risks and outcomes. So what you might want to do is see if you can try and resolve this dispute early without it escalating further, which risks, commencing legal proceedings or potential reputational issues, by exploring alternative dispute resolution methods. This might include external legal counsel or representatives to assist you with negotiations or mediations. And this often can be quite, despite what you might think, a cost-effective way of resolving disputes quickly and early. So you can arrange an settlement conference where you can reach out to the parties on the other side of the dispute, without prejudice setting, to discuss their interests and try and work towards a settlement. On the other hand, if you think that the settlement discussions need to be facilitated by a neutral third party, you might want to consider arranging a more official mediation. In our experience, we find that often having a mediator that's sort of acting kind of like an independent referee can really help push the parties to meet some common ground or compromise and resolve a dispute early. So by exploring these options, you as in-house counsel can often save time, expense, and uncertainty that can be associated with prolonged litigation. Now, if you reach a settlement early, it's also important to understand whether or not you need to have any agreement documented and what the impact of that will have on the business. You might want to be considering whether or not a deed of release is appropriate, for example. So handing over to Julia now, who's going to talk about some tips in terms of managing external legal counsel.
Thanks, Rebecca. So like Rebecca mentioned, there will be some situations where you will be considering whether to engage external legal representatives or even barristers or one barrister to assist with the dispute and potential court proceedings. So this could come up where you've tried to deal with a dispute, where you've tried some of those dispute resolution methods and they were unsuccessful. Or it might be that even before you've engaged in those sorts of dispute resolution methods, you find that the dispute is quite large and complex. And sometimes from an in-house counsel's position, there's not a lot of resources to deal with that from the get-go. Also, what we find has come up quite often is sometimes there are situations where there is, I guess, what we call a personal conflict for in-house counsel. So because in-house counsel lawyers have a difficult position where they are acting independently as legal advisors, but they're also employed by their ultimate client. So sometimes it becomes difficult, or you're put in a difficult position where you need to give some legal advice or advice on risks that you think, the ultimate organisation isn't going to like. Or sometimes there are some difficult legal concepts, outcomes and strategies that you can't quite communicate in an effective way to the relevant stakeholders. So that might be management and the relevant employees. So it becomes quite important to be able to reach out to some external lawyers to get some assistance and ensure some effective representation. This doesn't always need to happen during court proceedings or when court proceedings are commenced. There is some benefit, and a lot of benefit actually, in engaging external lawyers early before all of that gets started. So when considering what type of external law firm to engage, in-house counsel can consider things like the relevant expertise of the law firm, if they've had experience dealing with similar matters in the past, their reputation and what their fees look like, as well as how complex the matter is and how litigious the opponent is as well. So once you have engaged external lawyers, in-house counsel still retains quite an important role and a relevant role in assisting throughout that process and assisting the external lawyers as well to prepare and manage the dispute and any potential litigation. There are various ways in which in-house counsel can assist in this process, and we've listed a couple of them on the screen, but largely they include things like providing clear instructions and objectives to the external lawyers. So in-house lawyers have a very unique position where they're quite involved in the business and the operations and the day-to-day management of the ultimate organisation. So they're aware of things like the goals, priorities, the risk tolerance of the organisation, as well as specific legal or business considerations that might impact the case. So for example, if the company's or the business's reputation is quite a big risk factor, there might be ways in which you consider or suggest to deal with a dispute in a confidential manner outside of the public view or outside of the court system. So that might be a situation where in-house counsel and external counsel work together to try and arrange a confidential informal settlement conference or a mediation. This part or this role also includes making sure that you have the appropriate team members involved. So you want to make sure that you're dealing with people that have decision-making abilities and people in the organisation that can bind it if you come to an agreement or if you're providing instructions to external lawyers or barristers, as well as people that have intimate knowledge of the dispute and it's what's happened up until that stage. Another role that in-house lawyers have is, like Rebecca mentioned earlier, is gathering and organising the relevant documents. This is an extremely important part of the process and it does take quite a bit of time. And like Rebecca mentioned, it is helpful to have that done as soon as possible, but that includes collating things like contracts, correspondence, financial records, and any other key documents, and packaging them up ideally in a way that's well organised and comprehensive so that when you pass on that set of documents to your external lawyers, it really streamlines the process. So if it's in court, it can help quite a bit with the discovery process and the evidence process, and it can help the lawyers in assessing the legal position, the documents, and any strategy moving forward. Another important role that in-house legal counsel have is identifying and contacting relevant witnesses. So really, you'll be identifying who are the main people that have been involved in the dispute, anyone that might be relevant for the purpose of providing evidence, so anyone that has first-hand knowledge about what's happened. So you can work with your external counsel to assess the strengths and weaknesses of each of those witnesses and whether you want to actually approach them to provide some evidence. Another important role is providing insights into the company's business and its operations. So like we've mentioned, as an in-house lawyer, you have a deep understanding of the company's business and its operations. And that can be really invaluable to external legal counsel when they're preparing for a dispute. And this could include understanding things like the structure of the business, the processes, and the culture and the context of the dispute, really, to help understand that. And it might sometimes assist in anticipating some potential challenges or opportunities that could come up. So, for example, where we've seen this quite a bit is a lot of the times our clients are either aiming to raise funds or investment in the future or in the near future, and engaging in court proceedings can severely impact that. So it's important to know what plans the organisation has moving forward and how that could impact a strategy when it comes to a dispute. Another important point, and a very sore spot for a lot of organisations, is managing budgets and resources. So as we know, litigation is a very costly and time-consuming process, and in-house lawyers really have an important role in managing those costs, the budgets and the resources. So, for example, like we know, sometimes if it's a very complex type of dispute, it can be in court for 2 to 3 years, and the costs can very quickly explode depending on what happens in the proceedings. But, you know, they can be somewhere from $10,000 all the way to $100,000 or more. So it becomes really important to be able to manage that in a realistic manner, in a way that would work best for the organisation. Another important role, of course, is facilitating the communication and collaboration. So in-house lawyers really, in these situations, act as a central point of communication. So they speak to the internal stakeholders, so senior management and the business units, and maybe some outside vendors that might be relevant. And at the same time, they communicate all of that to the external legal counsel in a way that will assist them, and vice versa. So it becomes really important to have an in-house counsel that's able to effectively manage and work together with all of those different stakeholders and assist the litigation process moving forward. And look, what would be one of the most important roles of in-house counsel during this whole process is just providing ongoing support and guidance to external counsel. So, we found it quite helpful in situations where we've had in-house counsel that are quite involved in the proceedings. A lot of the times this could include reviewing and providing feedback on pleadings. Like we said, in-house counsel have quite intimate knowledge of the facts and the background of the dispute, and that can be quite invaluable. And also comments and feedback on any other legal documents. But also importantly, dealing with discussing strategies and settlement negotiations as well. So that can really assist and progress the litigation process, but also ensure that the company's interests are being effectively represented each step of the way.
Thanks, Julia. Look, so one of the most important things that in-house counsel should be aware of is maintaining legal professional privilege over information and essentially taking steps to avoid an inadvertent waiver. And in-house counsel should be taking proactive steps essentially to maintain the confidentiality and privilege over particular information and documents. So look, as we know, but as a quick refresher, legal professional privilege, or LPP, will attach to documents and communication that are created for the dominant purpose of legal advice or litigation. And essentially by having documents protected by privilege, these privileged communications cannot be disclosed to third parties or used as evidence in court unless there's express consent given or a particular exception applies. But quite often LPP or privilege over documents can be inadvertently waived. And we see this often in circumstances or in case law where many people are obtaining copies of the advice and legal documents when it's not particularly relevant to them. So examples of this could be where information is sent to a number of people. It contains some legal advice or certainly information for the dominant purpose of obtaining legal advice. And there's just essentially too many people on the email chain. And instead of replying all, recipients could start, separate threads of communication, and each communication will be treated separately and individually. And when they're not directly sent to and from lawyers, the risk of waiver of privilege will be much higher. So, it's important to sit down and think about who you're sharing the information with, and make sure that you're not sharing information or engaging with too many stakeholders. So you need to think about who really needs to be involved in the litigation process. Who do you need to be signing off on decisions along the way, and who needs to be involved in those communications. But also making sure that you're taking proactive steps to educate the people that you're sharing information with about privilege, what it is, how it's created, but also how it can be waived. So the people who are receiving your communications are aware of what they should be doing, and making sure that they're not engaging in any conduct that could risk a waiver of privilege. Your company might also have already established authorizations and delegation guidelines and policies, but otherwise, if not, this is something that you should be making sure that you're taking steps to either create, establish, and certainly keeping updated. These types of documents will provide clarity on the people in your business to the people in your business about the decision-making process, and ultimately who's going to be responsible for core decision-making when it comes to the dispute. So when it comes to settlement, it's important to not only think about who's got the authority to make the decisions and provide instructions to you or external legal providers, but it's also important to think about the other parts of the business that are going to be directly impacted by any agreements reached. So, for example, whilst you might have a CEO or managing director signing off on the ultimate decisions in relation to a settlement of a particular dispute, you might also want to be aligning any decisions made with the finance and tax departments. For example, you might need to be aware of the cash flow situation of your business or any tax implications of any agreements reached to ensure that the business is financially prepared for the consequences. Likewise, if your settlement includes taking some proactive steps by your organisation, making sure that those people needing to undertake those steps are aware, they're aware of any time restrictions or obligations, and in fact, essentially what you're agreeing to do can practically be undertaken by the company and the people involved. So if you don't establish the core decision-making team early and project the matter from the start, you might find yourself that, decisions are being made that are not authorised. You can face delays when seeking guidance on key decisions, or even discover that some of the decisions that have been made weren't even in the commercial interests of the business. So again, this just reiterates the importance of having the right team working on the matter, clear protocols about what information can be shared, and ensuring that the information that you're passing is protected by privilege. And I guess that you're just aware of who needs to be involved in what, to making sure that you're getting the right information to make sure that you're managing the dispute appropriately. So handing back to Julia, who's going to be talking about commercial strategy.
Thank you. So as part of the dispute process or litigation process, it's always important to align the strategy with the overall business objectives. So to effectively do so, it's important to have a deep understanding of the organisation's commercial drivers. And this is something that in-house counsel are usually quite intimately involved in. So this could involve things like engaging with the key stakeholders across the organisation, senior management, sales, finance, even operations, to gain some insights into the potential risks and any opportunities that might be presented by the dispute. So we like to say that in-house counsel effectively acts as a project manager of a dispute, and they really are the communication or central point in communicating these commercial implications of the dispute to external legal counsel and then back to the organisation as well. So like we've mentioned earlier, sometimes if there are significant impacts on the company's operations or reputation that come out of a dispute, sometimes external legal counsel might recommend a bit more of an aggressive approach to protect the company's interest. As another example, if the dispute presents an opportunity to strengthen a key customer relationship, for example, they might suggest a more conciliatory approach. But it really depends on the circumstances and understanding the context and the business drivers behind it. So look, it's important to assess the main sort of things that come up when we speak about commercial drivers, which are things like reputation, finances, and operations. But largely this involves considering things like the financial value of the dispute and the potential costs of litigation. So like we mentioned, the potential cost of litigation can be quite significant depending on the complexity and the type of dispute, and also depending on the type of party you have on the opposing side. So it's important to consider that and how that works within the organisation's goals. Another point is to consider the impact of the dispute on the cash flow and future profitability. Like we said, will it impact the ability to raise further investments? Will it take money away from projects that have been earmarked for the immediate future? Another point is to consider the potential reputational damage or publicity arising from the dispute. So is this something that we want to be dealt with in court that people might be able to read freely in the public, or it might be reported by the media? Or is this something that we'd like to consider taking into a more confidential forum, such as alternative dispute resolution type scenarios? Another point is the effect on the dispute on the company's relationships with customers, suppliers, and other stakeholders. So, for example, if you're in a contractual dispute with a supplier of some sort, but you do want to continue engaging them and you want to keep that business relationship, that is a pretty important commercial driver in understanding how to deal with a dispute. We've seen many cases as well, for example, where organisations are in dispute with landlords or with tenants. And it's a question of assessing, well, do we want to retain this business relationship, or is the organisation happy to cut ties? And that will significantly impact on the strategy and really how aggressive to take things. And most importantly is also the operational disruption and resources required to manage the dispute. So a lot of times businesses and organisations don't quite understand the amount of time and effort and resources that go into dealing with a dispute. And this is time, effort, and resources taken away from making money or doing what the business does on a daily basis. So it's quite important to weigh that up as well, so that in-house counsel can provide some strategic advice to the business and the most appropriate course of action. And like we said, it could include going all the way to litigation. It could include taking some consideration of dispute resolution steps. So it is important to take this wholehearted and a whole approach in considering where to go, what strategy to take, and taking these commercial drivers into account.
Great. So look, managing disputes presents an opportunity for continuous improvement and learning. And these are, this is really essential for in-house counsel to continue to enhance their dispute management capabilities and ensure that their organisations are well prepared to handle future disputes effectively. So one key area where continuous improvement is particularly important is in the discovery or document gathering process. So where, as we know, discovery is essentially a crucial step of any legal dispute. Most of us lawyers despise it, but it is significantly important. It's the stage essentially where parties are required to exchange relevant information and documents. And realistically, an effective discovery can make or break a case. So it's really important that in-house counsel have robust processes in place to manage this process. So some practical steps that in-house counsel can take to improve their discovery processes are ensuring that you've got a legal hold policy or direction in place. So as I mentioned before, when a dispute arises, the collection of relevant information is really important. And it's important to make sure that any documents, electronically in particular, are identified and preserved. In-house counsel will need to communicate directly and clearly to the business that a dispute is live and no documents or records should be deleted. And this is going to help avoid a situation where relevant information is, was available, but it was essentially lost or destroyed. A formal legal hold policy or direction will essentially help ensure that everyone in the organisation understands their obligations in this regard. And it's important to have that policy or direction, drafted and ready to deploy. The last thing that you want to be doing when you're faced with a dispute is then sort of just trying to gather and pull together a policy that you can deploy. You want something in place, being proactive to make sure that you've got something that you can deploy as soon as you're faced with a dispute, so that you can just focus on getting the information secured and starting to be collected. Secondly, it's really important to work closely with your IT team, and important to do this from the start. So discovery, as we know in this modern world, it's not just about hard copy files and documents on people's desks anymore. It's about locating electronic information. So it's being able to identify where it's stored, how it's stored, and how we can access it. So it might involve locating electronic documents, computer systems, servers, or digital folders. So engaging with the IT team early and having a really collaborative relationship with them is going to be really important in this process and help you understand how information is stored in your organisation. The IT team, your IT team, should be able to assist you with searching archives, restoring backups, accessing legacy systems as needed. Now, if you don't have a well-established IT team, there are certainly external providers that can help with this process. But, it is still important to understand to what extent the people within your organisation can help you access the information. But really, it's mostly about understanding how the information is stored. And kind of that ties in also to a question of understanding how the people within your organisation are communicating with each other. How are they tracking relevant information? So is it a matter of only, things are only sort of communicated via email? Or, should you be looking for memos, file notes? Are there particular areas in the drive where documents are held? So really understanding the way that your organisation works in terms of creating and generating information is going to be really important as well. So in addition to kind of having that legal hold policy direction, as I mentioned earlier, you should have make sure that your organisation's got document retention policies. So this is going to be really important in the event, we always have to counter for worst case scenarios, that your organisation's discovery process is challenged. You want to be able to point to a policy or a document that's been in place for some time that sets out, how information is stored and maintained within your organisation. So having a formal retention policy can help show how your organisation has a systematic approach to record keeping and how relevant information documents are preserved or how long you might maintain them before they're deleted. So in addition to these specific steps, there are some also, your in-house counsel should also be focused on continuous learning and improvements more broadly. So this could include, conducting post-case reviews, or as I sort of call them, a lessons learned opportunity. So, if you've got a significant dispute, you might want to sit down after the dust has settled to really review the process, identify what you've learned. What gaps did you identify along the way, and what areas could you or the organisation improve in? This process, should be collaborative. So you might want to seek feedback from external legal counsel, business stakeholders, and your other team members. It's important to critically evaluate the dispute management process and identify opportunities to streamline process, reduce costs, and improve outcomes. So again, updating policies, procedures, training. So it's making sure that all of the policies that you have in place are relevant and identifiable. So making sure that as there are legal developments, as they emerge, best practices evolve, that you're updating and reviewing your organisation's policies and making sure that they're relevant. Again, you might want to consider reviewing and revising contract templates, or providing additional training to your employees on particular topics such as document preservation, retention, and certainly legal professional privilege. Finally, you might want to consider sharing knowledge and best practices with your peers. In our experience, in-house legal counsel can benefit greatly from sharing knowledge and best practices. So this might involve participating in some industry groups, conferences, joining online discussions or forums, or simply reaching out to other organisations for advice and guidance on how they manage these day-to-day issues. By learning from the experience of others, in-house counsel can stay up to date on the latest trends and techniques in dispute management. So look, that really covers the main part of our webinar. You might find one of our publications useful. It's our guide to resolving business disputes. You can download this from the resources tab in your portal online now, or you can scan the QR code on screen and you'll be able to download a copy. We also have another upcoming event, again, focused for in-house legal counsel that you might find relevant. It is IP for in-house lawyers, protecting your organisation's assets. And that's taking place on Thursday, the 26th of September at 11 a.m. And you can register online via the website shown on screen. Finally, I just want to give you a brief explanation about LegalVision's desk extension. So, having spoken to hundreds of C-suite and in-house legal counsel, we understand that in-house lawyers are increasingly being pulled in many directions. They're often required to provide input on business critical and strategic matters at the executive level, but also managing a high volume of business as usual needs. This also needs to be managed within a tight budget and in even a tighter labour market. So under our desk extension product, LegalVision can assist you with your business as usual legal needs and allowing you to focus cost effectively and allowing you to essentially cost effectively increase the bench depth and capability of your team. And so you and your in-house counsel colleagues can focus on those business critical matters. Our desk extension lawyers invest upfront in understanding what's important for your business and work as an extension of your in-house legal function. To find out a little bit more about how our desk extension product can help you, please provide your details when the survey appears at the end of this webinar, and we can reach out to you. So now we've got the time to answer some of your questions. Please submit them in the webinar chat box. We'll just get started with a couple of questions that have been submitted prior to the webinar. Julia, you might address this first question. What are some practical suggestions on how to best approach this and ensure that our contracts are legal?
Thanks. So look, this is a good question, and I guess practical suggestions of dealing with the dispute are pretty much what we discussed in the webinar. But the question on, I guess, whether contracts are legal is quite a broad and specific question. We'd be happy to discuss it with whoever asked this question outside of the scope of this webinar, and we can discuss that further. But look, like Rebecca just said, and when she ended the discussion, insofar as the question relates to kind of keeping your contracts up to scratch when you're dealing with a dispute or after dealing with a dispute, it's always a good idea to stop, revisit all of your contracts to see if there's anything that you can do to update them or make them more applicable, given the lessons you learned from the dispute.
Yeah. We've got a question here. Issues regarding not aggravating injury, especially around capacity and mediation or facilitated discussions. I'm happy to speak to this. I've actually got quite a lot of experience in participating in I guess some personal injury disputes where the party on the other side of the dispute had some significant issues about capacity, and certainly the nature of these disputes was fairly sensitive. So from my personal experience, if you're trying to resolve a dispute with a person where you think that they might have some issues about capacity, so that might be capacity to take part in discussions or to make informed decisions, it might be worthwhile taking some proactive steps before any discussions take place, that there's been an assessment of that person's capacity by a qualified professional. And this might be important, to make sure that you've fulfilled your obligation, professional obligations, in making sure, and also, I guess, to make sure that any agreements don't become unstuck. If there's any suggestion that the person was actually not fit to, understand what was going on or provide instructions. So, some other things that you might want to consider when you're having or facilitating mediations like this is, I guess, reaching out to the other side's representative if they have one, to see if they've got any particular needs that need to be met. You might want to, if they're not represented, you might want to reach out and suggest that they get an independent advocate or a litigation friend, support person to help represent their interests. You might want to adapt your communication to make sure that you're, suiting the individual's needs and abilities to understand what you're conveying. The mediation or discussions themselves should be structured in a way that's not going to exacerbate an individual's condition. So you might want to consider shorter sessions or frequent breaks, and making sure that if you actually are having a mediator, that they're actually quite experienced in dealing with, persons who might have some capacity issues. It's also really important to think about the location of where these discussions are taking place. So, you might not want to invite someone to front up to your beautiful commercial, premises. You might want to think about having a sort of a neutral and very accessible venue, and certainly one that can accommodate any physical limitations. But, ultimately, in the day, you just need to approach these sort of matters with a degree of flexibility and be prepared, that things could go awry. But you also just need to make sure that the steps that you're taking are not going to be causing undue stress or potentially aggravating an injury. Lots of comments I could share on that. So, more than happy to address these in a consultation if you'd like to know. I've got a question here about appreciate your thoughts on approaches to balancing legal professional privilege and reporting to stakeholders such as directors and executive team members. Yeah. So, balancing legal professional privilege and reporting to stakeholders is, obviously something that's really important. So, as we said, it's about identifying who you need to communicate with, and also just making sure that you're not mixing your, the advice that you're giving with sort of, I guess, other work or other reports that you're providing to these stakeholders as well, so that there's no inadvertent disclosure there. Again, some practical tips would be, writing. If you're writing, making sure that you're marking it as confidential and subject to LPP, and maybe providing some guidance that it shouldn't be distributed without, speaking to you first. And, making sure that you're taking some proactive steps to educate the people that you're working with, and having some policies in place about not sharing legal advice or correspondence. As a quick tip, Julia and I actually presented a webinar for in-house counsel on this very topic. It's available on YouTube. It's called Navigating Legal Professional Privilege, Conflict Strategies for In-House Legal Counsel. So definitely recommend that you check that one out, because it does delve quite deeply into, legal professional privilege issues.
Just following on from that one, Rebecca, it looks like we've got a question that's just been submitted, and it's a similar topic, but the question is, how can we convince employees of the importance of privilege? Are there any examples we could give them of why it's important? And I think that's hitting the nail on the head. I think in trying to explain the importance of it, examples are key in understanding how it works. I know that there's quite a bit of case law about various situations in which privileged advice and information has been inadvertently waived. There are some cases where, for example, there's been a media release made by an organisation, and it's as simple as sometimes, depending on the circumstances, but it's as simple as sometimes just referring to obtaining legal advice that you have a strong position. And saying something as simple as that sometimes is enough to waive legal professional privilege in that advice. Now, what the consequences of something like that could be, look, if you're in court, it could be that the other side or your opponent tries to obtain a copy of that advice, and you can no longer seek privilege. And what that does is it impacts your strategy, your case theory, and all of those things, and can significantly cause a lot of detriment, potential loss and damage to the company as well. So it is definitely good. I know there's quite a bit of case law up and about those kind of situations, but they're probably some good examples. Rebecca, did you have any examples?
Yeah, I agree with that.
Yeah.
I guess we'll just quickly move on to one more question. It's actually on privacy. So it says, would be helpful to understand some practical examples of how your clients meet the privacy requirements within a large organisation, and what other teams within a large business should be involved in this process in addition to in-house counsel. So look, happy to maybe explore, privacy obligations in a consultation, because it's sort of a bit off topic of what we're talking about, definitely related. But look, in our experience, where I see a lot of privacy issues or disputes in relation to privacy arise is because organizations will take a step of getting a privacy policy. They have it in place, it's published on their website, but then they actually, haven't taken the time to, essentially train their staff on what that means in terms of a practical application and how it's going to impact their day-to-day. So, for example, I've dealt with a dispute where, the client organization had a great policy in place, but when it came down to the practical reality of what employees were doing, and in this case, there was a breach of privacy, it just actually demonstrates that, there was a disconnect between, the policy and actually how there was, how the business was operating. And so, it's a matter of making sure that in-house counsel are making those connections, are reflecting on the way that organizations work and making sure that, that they are, it's great to have policies in place, but it's also important to be making sure that, team leaders, the people responsible for training new staff are actually taking the time to invest in making sure that, their employees understand, the policies and how they relate to their particular role. Well, look, we haven't had a lot of questions, but I'm hoping that means that, that you've found that the webinar has been useful. We do need to wrap up, but, if you've got some other questions that you would like us to answer, you can certainly submit them still, and we can arrange for a consultation to discuss them. So, thank you so much for your time today. We've really appreciated sharing some of our experience in navigating disputes with you. Hope you've found it useful. Again, please complete the survey at the end of this webinar to let us know how we went. Your feedback is valuable. And while this was, and a free webinar, again, really want to emphasize that we value your time and coming on this journey with us. So thanks for joining us. And again, please book a call with our enterprise team if you'd like to find out a little bit more about desk extension and how LegalVision's enterprise team can work with you to reduce your in-house team's workload. Thanks so much. Bye-bye.
Thank you, everyone.